Okay, salam sejahtera kepada Miss. Nama saya Lily Elizabeth. Nombor kad matrik 20 DPM 19 F.023. So, saya buat video untuk case study. Section A, soalan 1. So, soalan 1 dia ingin state an issues. So, in this case, the issues is whether Namjoon as an agent was instructed by his principal to find a buyer for a bungalow that the principal intended to sell with the commission 5% of the price of the house. Jimin offered to buy the house at the price of Rm 5,100. Then Jungkook offered to buy it 5,100, but then Jimin offered an additional commission to Namjoon. In implied appointment, the law can infer the correction of the agency by implication when a person by his word or conduct hold out another person as having authority to act for him. So, untuk soalan 2, dia explain the relevant provision of the Contract Act 1950. So, according to section 140 Contract Act 1950, an authority is said to be expressed when it is given by words, spoken or written. An authority is said to be implied when it is to be inferred from the consummation of the case, and things spoken or written or the ordinary course of dealing may be accounted consummations of the case. Also, according to section 135 Contract Act 1950, an agent is a person employed to do any act for another or to represents another in dealing with third person. The person for whom such act is done or who is so represented is called the principal. And according to section 134 of the Contract Act 1950, an agent is bound to conduct the business of his principal according to the direction given by the principal, or in the absence of any such direction, according to the custom which prevails in doing business of the same kind at the place where the agent conduct the business. When the agent act otherwise, if any loss be accrues, we must account for it. Soalan nombor 3, explain a relevant case to support your answer. So, applying into this case, Keppel v. Weller, 1927, the defendant was employed by the plaintiff to sell his house. An offer was received and accepted by the plaintiff, subject to contract. A few days later, a higher offer for the same property was made by X, but this offer was not communicated to the plaintiff. A written contract of sale between the plaintiff and the first offer was duly signed. The court held that the defendant was liable the plaintiff for the difference between the two offers. The inference is that the agent must disclose everything come to his knowledge which is likely to influence the principal in making of the contract. Soalan nombor 4, conclude your answer. So, as a conclusion, according to section 135 Contract Act 1950, Namjoon as an agent is a person employed to do any act for another or to represent another in dealing with third person. The person for whom such as is done or who is so represent is called the principal. So, itu saja dari saya. Sekian, terima kasih.
Selamat sejahtera, nama saya Clarish. Saya akan terangkan tentang case Yang section B nomor 3, pasal Syafiq, the owner of a Proton X70, delivered the car to Ayub, a mercantile agent, for sale for a price not be less than Rm 80,000. Ayub intended from the very beginning to sell the car immediately for the best price he could get to use the proceeds for his own purposes. On the same day Ayub received the car, he sold the car for 75,000 ringgit to Daniel, who bought it in good faith and without notice of the agent. Shafiq therefore sued Daniel in order to recover his car. Jadi jawapan yang pertama adalah whether Shafiq can get his car back or not. Dan seterusnya ialah principle of provision in Saga 1957 that are related to this matter. The answer is Section 27 of Contract Act 1957, subject to this Act and of any other law for the time being in force, where goods are sold by a person who is not the owner thereof and who does not sell them under the authority or with the consent of the owner. The buyer acquires no better title to the goods than the seller had, unless the owner of the good is by his conduct precluded from denying the seller authority to sell, provided that where a mercantile agent is with the consent of the owner in possession of the goods or of a document of title to the goods, any sale made by him when acting in the ordinary course of business of a mercantile agent shall be as valid as if he was expressly authorized by the owner of the goods to make the same, provided that the buyer acts in good faith and has not at the time of the contract of sale noticed that the seller has no authority to sell, as Daniel doesn't even know anything about Ayub's intentions from the beginning. And then question 3 is discuss the relevant case regarding the issue mentioned above. And the answer is Fox versus King. Fox left his car with a mercantile agent and told him not to sell it below a certain price. The agent sold the car for less than the minimum price to King, who purchased the car in good faith and for valuable consideration, without any notice of any fraud. The agent then disappears with the money. Fox sued to recover his car from King. The issue was whether King received goods title, held that as the mercantile agent was in possession of the car with the consent of the owner for the purpose of sale, and as the sale being in the ordinary course of the agent's business, the purchaser received a good title. Fox therefore could recover the car from King. And for the conclusion is, Daniel did not know about the car problem as he bought the car with good faith from the mercantile agent. As the mercantile agent was in the possession of the car with the consent of the owner for the purpose of sale, and as the sale being in the ordinary course of agent business, the purchaser received a good title. Ayub could recover the car from Daniel, and I think that Ayub can sue the mercantile agent as he didn't follow what Ayub has told him before. And that's all for me. Thank you.